How serious is a non-compete agreement? It's very serious. They're very hard to enforce. The most valuable part of a non-compete agreement for an employer is the fact that it exists. Its existence has a chilling effect on an employee's ability to go get another job, start a new company, go into competition. And so it's very serious. If you're right, if you have a non-compete agreement that is not enforceable, that's sometimes worse than having one that is, because then you have to say, okay, is it worth me defending my rights under this non-compete? And even though you might ultimately win, the cost of doing so can be prohibitive for an individual. If you take these things to the mat, it can be mid 5 figures to 6 figures to litigate one of these things. So to be right can be expensive. And so non-compete agreements are very serious, and whether you're trying to enforce one or whether you're trying to get out of one. And I'm very fortunate in that I've had a lot of reps with non-competes. I think I've had as many reps with non-competes as just about anybody in town. And I've litigated them all over the country. And the ramifications can be extraordinary. Whether you're an employer trying to protect a book of business or trying to protect a trade secret or a process, or whether you're an employee trying to make a living after you've been fired or after you've left another company or being treated unfairly in another company. These agreements are all enforced using a court's equitable power, which for the lawyers know what that means. That's the court sitting as a court of equity, which means they have a lot more discretion and authority to be fair and to do the right thing. And for non-lawyers, it means, bottom line, every case is different. Every situation is different. And if you've used a non-compete agreement and just got one off the internet, it may or may not do what you want it to do.